topic today. Thank you for being with us today. I am Angela Lopez. I'm an attorney and shareholder with Cowles Thompson. And you already know I have been practicing immigration exclusively for the last 16 years. With me presenting today is attorney
Michelle Alonso. Thank you for having us.
Okay, just a couple of things before we start. If you can please, we're going to be muting our phone your phones during the presentation, so to avoid any noise or background interruptions. We want to give you the opportunity to ask questions. As always, you can type your questions on the pen, and we will get your questions. We will answer the questions at the end of the presentation, and we'll try to go through the questions in the order that they are submitted. Hopefully, we're going to have a ton of questions, or if we have none, we'll know we did our job. When you ask the questions, please do not state your names loudly because we want to keep confidentiality. We are discussing today immigration for entrepreneurs and investors. We are first going to address temporary investor visas, entrepreneur visas, the E1s, E2, L1s. For those of you who are kind of familiar with these, those letters mean something. For the others, we'll give you the meaning of each one of those classifications. And then we'll go into the permanent investor entrepreneur visas, and those are the gray ones for the green card. So let's start. The first one is the investor E1 treaty trader visa. This one, and as the investor visas, is specifically for citizens of countries that have a treaty with the United States. As you might see in the slide, there is a link to the Department of State website where you can check out if your country is in the list of the treaty nations which that qualifies for E1 treaty trader visas. If the country is not there, you might not be able to qualify. However, if you have a dual citizenship or you are a citizen of another country that might be on the list, then you might be able to obtain the E1 treaty trader visa.
And we've advised a lot of people who may have access to dual citizenship and hadn't done it to go ahead and go forward. For example, we've helped a lot of Venezuelans who actually have double citizenship with Spain, and Spain is a treaty country, to go in and get their Spanish passport and then go through the process through Madrid.
Correct.
To come in as investors. Though they may have never stepped a foot in Spain, but for that interview, they're citizens of
I agree.
Spain.
And yes, and we do that frequently, and we have never had any problems in terms of consulates not honoring that's dual citizenship or denying a visa because they were never a resident of their state. If you have that citizenship option, use it.
Exactly.
Yeah. Then the couple of main requirements is, carry on substantial trade. As the name of the visa says it, this is an E1 treaty trader, meaning there's have to be trade between the United States and the treaty country. So if you are from Spain or Italy or Colombia
or
Mexico, then there has to be trade between the two countries. They are couple of things. What does trade means? And we get that question asked frequently because for some people trade might be services instead of goods, or international banking, insurance, transportation, tourism. Those are just some of the examples, but that is not an exclusive list. So whatever is the international exchange of items between the two countries, that is what will constitute trade. For the E1 treaty trader, there's got to be substantial trade. What is substantial trade? Well, trade we know is the continuous flow of international trade items.
Or services.
Or services, yes. And the Department of Immigration looks at numerous transactions over a period of time. Usually they say it's a year. They want to see like a year history of the transactions, and there's got to be some sort of consistency. It's not like 1 month there was this volume of trade, and then for the 6 months there was nothing. They want to see continuously and consistent trade. They look more at the volume rather than the monetary value. However, they do look at money, but they want to see volume and consistency over a period of time.
Right. And just to give an example to that point, I previously worked on a case where we didn't have such a good track record of numerous transactions, but the monetary value over the course of 1 year of these trade exchanges, I think, amounted to $14 million. So that was what tipped them and this was a trade of large equipment and oil and refinery. So they do take into consideration. Now, we did go into a bit of administrative processing while they looked into it and decided, yes, we will give the visa. But it was an argument that we had to give weight to the fact that monetary value in here should be looked at and not exclusively at the number of transactions.
Yes.
So there is some wiggle room, right?
Yes, there is. And it's good to make this distinction because we're going to go into the E2 visa, and so you can see how different these two visas are in terms of what they pay more attention to. In this specific one is the volume of trade over the money. But speaking of the period, I also had a case where, yes, they usually say it a year, but I had a case recently where my client was doing trade only for about, I believe, 6 months or so. Mm-hmm. And we submitted the visa because they have enough track information and track records to show they had been doing consistent and volume trade between the two countries. And even the consular officer made the observations that they usually do not approve these visas without a full year of records. But in this case, there was enough volume and consistency that they approved the petition.
As a very happy client.
The trade that exists, the trade between the two countries, got to be over 50% of the total volume of trade items, which means that, for example, for those people who trade with different countries, different products, if the e-visa is based on a specific nationality or treaty country, then at least 50% or over 50% of the goods or services that are being exchanged must come from that country, treaty country. Treaty trader, period of stay is an initial stay of 2 years, meaning once the petition is approved, the visa is granted only for 2 years at the beginning. They can, for extensions can be also granted of up to 2 years each increments, and there's no limit on the time and the number of extensions, meaning someone can have an E1 treaty trader visa indefinitely as long as they are able to show that the business continues to meet the E1 treaty trader requirements. Travel abroad, this is frequently people see that every time you come back to the United States, you get a new I-94 form, and usually what they do is they stamp a new 2-year period. So, for example, you come into the United States with your visa, and they gave you a date of October 2020, and in December you leave. 19 is 2
right.
years. 20 we're talking 3. So October of 2019. So in December you leave again and you come back, and then they're going to give you December of 2019.
Yes.
So every time you come back, they will extend it to match the 2 years period that you would be authorized to stay.
Right, and I think it's important that we also point out that that's assuming that you have a visa. Now, there are particular countries that will allow only single entry visas. So if you want to go out, you would actually have to go out and apply for a new visa because you have used your single entry. But those are really country specific, so keep that in mind, though, when you're looking up on that list.
Yes. Then dependents, because we always want to know, well, what about my husband and my wife or my children under 21 and single? They will get the same courtesy of the visa, meaning if the principal got the E1 visa, well, they will get E1 non-immigrant classification for the same period of the principal or the spouse or the parent. And the spouse, who is not the principal petitioner, might apply for an employment authorization once they enter the United States. And this is great because once they obtain that employment authorization, they are not subject to working with the enterprise. They can actually work with anywhere, any place with that work authorization. Now we will go into
E2, treaty investors. So this is a particular favorite classification of mine. But again, just like the E1, you're going to want to look at the nationality of the individual, of the investor. Are they on the list? Because if you can't get past that inquiry, if they're not on the list, there's no E to entertain. The E2 is different, though, because you will have to have invested or be actively in the process of investing. And this can be very convoluted, and it could probably be a webinar all in and of itself. But some of the other requirements are the substantial amount of capital, the investment, and that the capital is at risk, and that we're discussing a bona fide enterprise in the U.S. Now, each of these are listed separately, but they all sort of work together. So with a lot of folks who are looking to actively invest in a process, we're looking at business plans that sort of outline everything, but we're going to go over the fact that a lot of this is going to really come back to the capital and that it's being placed at risk to be considered a legitimate investment. So to have invest or actively be in the investing is the business operating. So the first thing we look at is, are we looking at an established business or are we looking at a new business? And that's really going to differentiate the approach that we would take with the case. One is going to be heavily focused on the track record of the business, and so we can show that the business is operating, but we'll show kind of how it's been operating. Mm-hmm. Or if it's a new contemplated business, then we need to see what steps are being taken to create the business and get it basically live. Again, you're going to hear this a lot. Substantial amount of capital. Everyone asks, Angela, what's the amount I have to invest to get an E2 visa?
And that's the $1 million question.
But it doesn't really cost $1 million.
No, not this one.
No. But what is substantial? Everyone wants to know what substantial is. And the fact is there is no definitive answer. We do know anecdotally that some consulates, we are told, don't look at certain dollar amounts as serious, others do. But when we're looking at a case, we're looking at, is it substantial in relationship to the total cost of the purchasing enterprise, the one you're buying, or the one you're establishing?
Yes, and I always like to give examples and extreme examples because I'm a visual person, so I need to kind of be able to picture it, right?
Okay.
So one of the examples I always give is, if you're thinking of and you tell me, well, I want to open a business to sell cars. Right there, in there, you know you're going to need a lot of money because you will have to buy cars to sell cars, and cars are not cheap as last time I checked.
And the lot.
And the lot and the whole operations of so that's a lot of money. So if that's the business in mind, you know your investment is not going to be minimum, or your investment can be just $100,000.
Right.
You need to look at the reality of your business. But if you're saying, well, I provide accounting services, and I'm going to open my office, and to open my offices and offer my services, the first year, I don't believe I have to invest more than $50,000 in a total of maybe $200,000 in a number of years. That might be reasonable,
right?
Because your services is your value,
right?
So that's what you're gonna. So it depends as to what type of business you're going to get into.
And on the slide, it makes a good point. So the lower the cost of the enterprise, the higher proportionately the investment must be to be considered substantial. So one thing that we always look at is like the first year of operation. So we look at quite a few benchmarks. But to answer the question, what amount for the E2, we don't know. It's going to be a substantial amount of capital.
Well, I think that I kind of have an idea. If you're thinking of investing $20,000, it won't work.
Oh, yeah.
It doesn't matter the kind of business. So you need to
And there are some consulates that we've been told won't look at anything below $100,000.
Exactly. And they tell you it's not worth even looking at the
right. And I'll look at them and say, well, it's substantial to the enterprise, and they won't. So, and you know, we work through that. When it comes to dealing with those consulates, we would advise you accordingly. Let's talk about the capital, though. Is it just money, or what does it mean when we're talking about capital? Well, the capital that they're talking about typically is the money, and it needs to be at risk. Be at risk. What does that mean? That it's subject to partial or total loss if the investment fails, and it does not have to be obtained. Well, that's separate. So the investment, and this is a recurring theme in these types of visas, it's not an investment if you're not willing to lose it. The idea is that if you have something structured in there to where you're going to be paid back, then immigration is going to look at it as it's not at risk because you're not willing to risk anything if this enterprise doesn't take off.
Well, the word itself says it. It's an investment. Investments are risky.
Right.
And you are putting your money to work at risk of losing it. That's what it actually means. So,
and I do think it splits between the people who are serious about investing versus the ones who aren't. Another big issue, and I can't tell you how often this comes up, and I wish it didn't. We have to show that we can trace this money and where these funds came from. And so, and the whole purpose behind that is they want to make sure that none of this money or none of the funding is directly or indirectly from criminal activity. So tracing for legitimate business people is a pain. But it's necessary, and most of the investors we've dealt with, though, have no issue with it because they understand sort of the underlying reason here.
I would say all of the investors we work with,
Right.
they don't have any problems with this issue because if there's a problem, then the visa is not going to work.
Right.
They look at the Department of Immigration is very, very, very cautious in terms of looking at the source of funds, and they want to know where the money that is being invested in the United States came from. So if we cannot show clear financial statements, clear banking statements, clear documentation showing how the money was acquired, then they are not going to approve it.
Right, and to that point, we will go to a certain point back for tracing. It's up to the consular officer if they want to go back even further.
Exactly.
So another thing, the enterprise may not be marginal. What does that mean? Marginal enterprises basically are ones that do not have the present or future capacity to generate more money than enough to support you and your family if you're bringing over your family. So if you're looking at netting a profit of about $60,000 a year and you have a family of 6, they might look at you and say, well, are you really just here living and surviving, or is this really something that's generating a real profit and really an investment for the community?
Yeah, and this is one of those areas where you can really make an argument. Yes, probably the first year is not going to be so profitable because most business in the first year, they really are not very profitable. And maybe you can show that you have other means to support you and your family, but that at the end of the day is the overall period of investment that is going to make sense for the business. So, okay, maybe the first year is not good, but look at the projections we have for the second year and the third year, which makes it worth it, and we're going to be able to make it work. So it's not a definite, if you're not profitable the first year, you can make it.
Right, and we make that argument
Yes.
a lot, that businesses are going to ebb and flow, and you have to adjust. And the beautiful thing about this, since we're looking at every 2 years, you can show that you've met your projections, or if you didn't, why you're set out to sort of continue with a new list of projections. Let's see.
So the 5-year projections, here is where we always talk about the business plan.
Yes. So I think the business plan is critical even for established businesses because you're showing the consulate or immigration, if you're doing a change of status, you're showing them that you're taking this existing enterprise or this new one and this is what you're going to do with it as the investor. You're investing and you're going to take it to this. Because most of the time it's a failing business or owners that want to get out, and the new investor comes in and purchases that business, and they're going to say, well, while financials looked like this for the last 5 years, with under my management and investment and development and direction, it's going to look like this.
Exactly. So the business plan to us, every time we do one of these visas, is the key piece of the investor visa. Is the document that we want to start reviewing and looking at and having a communication with the client from the beginning.
Right, and I will always worry when I get real generic business plans that have no specifics or no industry data or market data. Those make me nervous.
Yes, or you're halfway through putting the documentation together and you're still asking for the business plan and no business plan because there's no way to structure a good, sound petition without having the business plan first and upfront.
And quite frankly, it's pretty much a requirement for most consulates at this point.
Well, yes, that's what it tells the officers, what is the business? How it's going to grow? How much money I'm going to invest the first year, the second, the third, the fifth year? How am I going to be hiring people if I need people? And is the business itself.
Yeah, I can't agree with you enough. That is the roadmap. And so, going on and continuing with the theme of the roadmap, the bona fide enterprise in the U.S., they want to know that this is real, active, and operating commercial or entrepreneurial undertaking that is going to provide services or provide some sort of goods for profit. So, break that down. They want to know, where are the articles of incorporation? Where is this U.S. entity? How are they operating? Where's the business space? How are you handling payroll? How are you handling marketing? Whatever is specific to that industry and that particular service or good that you're providing, how is it really operating? Mm-hmm. And so I think that's pretty straightforward, but the idea is you must meet legal requirements for doing business in the U.S. So
one thing we always work with our clients and always ask clients to do so the Department of Immigration can see the bona fide enterprise is that when they are talking about how much money they are going to initially invest, like for the first year, if possible, that they open an escrow account in a bank in the United States and deposit that first year funds, the $50,000, the $100,000, whatever money is needed. So in an escrow account, so the officers can see that once they approve the visa, the funds, the first year funds are ready to be invested into the enterprise, so, and that's part of the investment.
Right, and that vehicle has been one that's been pretty sound, but I think you'll find that there's people of different opinion, but we've had really good experience with that.
Yes.
Okay, we're running. 2 years. 2 years for the E2 as well. Extensions are also granted for up to increments of 2 years. Again, there's no limit on the number of extensions. I think we've had numerous clients who've been here for, I think one client was at least 13 years.
I have a client, he's been here in an e-visa for 20 years.
Oh, 20. Okay, see, I think the most I've gone to
Not that I have been practicing 20 years, but he's been here for 20 years.
And so long as the investment continues, I'm sorry about that. It's valid. It's non-immigrant, but you'll see in these packages there's always a statement of non-immigrant intent that has to be established because you are in a non-immigrant visa classification, and I think that's something that attestation is included in every single one.
Yeah, and non-immigrant intention means that you do not have the intention to permanently reside in the United States, meaning you're not going to apply for a green card in the United States.
Right.
And you have to show that intention, even if you've been living in the United States for 20 years. Every time you renew that visa, you need to show them, I'm not going back. I'm sorry, I'm
Angela,
going back. I promise you, one day.
So Angela, if I can't show any ties, like say I got my E2 and I sold my house and I canceled all my cell phones, what's wrong with that scenario?
Yeah, no, I always tell people, keep some sort of ties. You don't have to keep a house. You don't have to keep big investment, but you need to keep some sort of ties, and we always include the intention to departure statement.
Right.
I know statements, but we trust that when the client is signing those statements, they are being truthful.
And I do know that London actually wants the evidence of the ties in the UK. So again, very consulate specific.
And for those ties, one of the things that we see frequently is that in most countries, people, even if you have investments outside your home country, and you are required to file some sort of tax returns.
Exactly.
And so you're supposed to show the government, even if you're not making the money within the country, that you are making some sort of money, and if you owe any taxes, you're supposed to pay them. So that's a pretty good
Right,
tie.
And the way we explain it, U.S. expats are expected to do the same. Most countries have a similar requirement as well, and we definitely advise our foreign national investors to keep up with those requirements in their countries. And just like the E1, your dependents will come in so long as the children are under 21, your spouses. The nationalities do not have to be the same as the principal, so we're only looking at nationality for the principal treaty investor. And the same period will apply, and also spouses get employment authorization, which is also a good bonus. For a new business or new company, the spouse getting the employment authorization I think is really important because the spouse can work for the company, and that's an added bonus.
Exactly.
Okay, so what happens if your country is not on the list? You have money to invest, you have a company, but you can't come over on the E. This is where we'll look at the possibility of the L. Now, the L is not really an investor sort of visa, but it is a way that we can help a foreign national investor from a non-E country, an entrepreneur, to come over, right? So it's an intercompany transfer. The idea is that we could bring you over on an L1B or an L1A. For the L1B, your U.S. company that's established, you would establish the U.S. company here, that this professional employee has some sort of specialized knowledge relating to the organization's interest in the foreign country. So you're saying, I have a successful business in this particular country that would do well and fare well. We think the U.S. market is where we want to go. We'll open our U.S.-based market office there, and we want to bring over this key employee who knows about the good or the product or the service that we want to sort of open in the U.S.
Yeah, or there's already an established company here in the United States, and they have a company outside the United States, and they want to bring that special knowledge employee to the United States to work with them. For purposes of this presentation, we're going to focus on the L1B rather than the special knowledge, which is this one. This one in itself is a little bit more detailed, more complicated. Is not commonly used. It's used, believe me, it's used, but the one that we see that is more frequently used is the next one.
Our L1A.
Exactly.
Very good. So our L1A is going to be the transfer of somebody at the executive or managerial level with the foreign affiliated company, and that foreign company wants to send them over. Now, that's an easier sell, I believe, as Angela is suggesting, because the idea is that someone at a top executive level is going to be the one that's knowledgeable to sort of forge forward this U.S. enterprise if the company already has their affiliate here in the U.S. or if they're establishing one.
Correct.
And so, let's see, the L1A, executive or manager, U.S. company transfers them over. Oh, I think that was a duplicate. My apologies. All right, a little bit more though. This is where we get to the meat of it. The qualifying relationship with a foreign company. This is a word of art. What is a qualifying organization? And then you have to currently be or will be doing business as an employer in the U.S. Other than in at least one other country during the duration of the L1A visa. So the qualifying relationship has to exist between the U.S. company and the foreign company, whether we're looking at it as a subsidiary, as an affiliate, as a parent organization. These are all that are defined really through documentation. So as soon as we know that there is a U.S. Office here, we just look at the documentation to see how was it established and can we show the relationship between the foreign company and the U.S. company.
And that affiliation is not necessarily through a parent company, branch, subsidiary. It can also be common ownership.
Right.
For example, if I, Angela Lopez, owned a company in Colombia, my home country, and I also own a company here in the United States, but between the two companies there is no relation other than I own both companies, that's an affiliation.
Right, and we do get quite a few of those where you have the same group of investors that come over and establish a U.S. company here, and there's not a clear relationship between the both, but the shared ownership is what's going to create that affiliation that allows you to take advantage of this L1A.
Correct.
So, doing business, that is also defined. It's regular, systematic, and continuous provision of goods and or services. And this is important because sometimes you can establish a company and it can be pretty dormant for several years.
Yes, or the company may just be formed to have an agent in the United States to provide and create businesses for the company outside the United States, but not necessarily doing business in the United States.
Right, and I had a situation where the company here was established just to ease payment of U.S. companies for services and everything that was being performed by the company abroad. That was not going to meet the doing business regular systematic because they were just acting as a clearinghouse. So that is important. Just because you have a U.S. business here, we need to look at how is it operating. Are you going to fall in that regular systematic and continuous provision? Definition. And again, it says it right here, it does not include the mere presence of an agent or an office in the U.S. Mm-hmm. So the employee, now we go back to the actual individual. The employee must have been working for the foreign company for at least one continuous year within the last 3 years immediately preceding his or her admission to the U.S. Now, this can get really complicated and convoluted, and we won't go into it, but if you clearly fall within the last, you can show within the last 3 years that you work continuously for this 1 year, easy. If you've come over on a different status, we probably need to set you up for consultation because that can be a little bit tricky on how we proceed. But the fact is, we need to show that the position that you're coming into is going to be that one as an executive or manager. And those are very, very specifically defined in immigration. Not every executive or manager is going to be an executive or manager for U.S. immigration purposes. And then the fun one.
The new offices. This one is for those entrepreneurs who have a company outside the United States and decide that they want to come and open a company in the United States, a brand new office. In addition to all the requirements that we just discussed about doing business and all of those beautiful things, there's specific requirements for new offices. And one of them, which it might sound very basic, but it has caused a lot of petitions to be denied, is that the offices in the Department of Immigration requires that there's got to be sufficient physical premises or space to house the new office. It has to be secure at the time the petition is filed. As you can see in these new offices, is similar to the investor visa we discussed, because the person is coming into the United States to open a new company, setting up a new company, kind of the same process of when they are investing. The difference is that they are going to come from another company outside the United States. So it's not like they are not tied to something outside like an investor would be, but will come to open a second company or third or fourth or whatever, but a new company as part of the company outside the United States. So they want to see enough space. What does that mean?
It means you're not going to get your visa if you can't show an office lease or of some sort.
So, Michelle, if I have if I'm providing services, it's my first year of here, I'm going to have the new company, and I rent an office with enough space for me and probably an executive assistant to assist me the first year with all the things. But my company in the next 2 years or 3 will require like a warehouse. Do I have to rent the warehouse from the beginning? It's a waste of money.
It is. But the suggestion is, and this is where we look at the business plan, the suggestion is if the whole purpose of the business operating is going to revolve around eventually opening the warehouse, you may want to go ahead and lease that warehouse space.
Because we have seen cases where, and with all due respect, I believe the officers of the Department of Immigration do a great job analyzing these petitions. However, we have seen cases where you provide all the documentation. We have even provided additional information with agreements signed between the landlord and the investor or the entrepreneur, stating that when they need more space, there is a space available.
Right, they're stair-stepping the progression.
Give them copies of the floor plans showing the spaces there for them to take over whenever needed, and we have still seen denials.
Right.
Because there is not enough space.
And that is really good to highlight. The L is under a lot of scrutiny. And that's not a lie. But the fact is the L is still available, and we can get cases through if they legitimately qualify. But that's why we have to advise. For example, this sufficient physical premise, I mean, we can't tell you how many clients have said, well, I don't really need anything but my home office. Why can't I do it out of my home office? Mm-hmm. And that's just problematic because you need to have the physical premise. USCIS is not exactly the most current in terms of business practices, so it's really hard sometimes when we talk to our business clients who are sophisticated and know how to run a business and say, well, this is just a waste of money. Mm-hmm. But then we have to balance the interest of, well, how much do you want to come in on this L1A and through this avenue?
Again, business plan.
Exactly.
The business plan, again, becomes a key factor in the L1A visa as it is on the investor visa.
Right. And so how long do we get? Well, you'll get an initial stay of 3 years. And this is on the L1A executive or manager. Extensions may be granted in increments of up to 2 years, but the maximum you're going to get on this L1A is going to be 7 years. Your new office is only 1 year, right? So the new office you'll only get 1 year.
And that's the thing. For the new office that you only get 1 year, what you're supposed to do is you're supposed to do such a great job that at the end of that year, you're going to be left out without a job because you're supposed to be able to hire a manager to replace you. Of course, you can always make the case and show that you continue to be needed in the United States to further develop the enterprise. But the presumption is that you will do everything so well that first year that you'll be able to hire someone to take your place.
Right, and that's the tough part about when you talk to business people, when they look at a genuine business progression, a lot doesn't happen in that first year according to our business clients. In some cases it does, but most of them it doesn't. And so this is sort of the hurdle that we have with the L's. But we go back to the business plan. If we can go and show that within the first year benchmarks have been made, and that goes back to how well prepared the business plan is and how rooted it is in real firm numbers.
And then the money again. How much money? Well, it depends upon the kind of enterprise.
Precisely.
So it follows the same structure as the investor visa. Depending on the business that you are opening, depending on the company, is the amount of money that you will have to spend.
All right. And dependents. So we always want to discuss your spouse and your children will come in as dependents on the L1A. Not a problem. They're categorized as an L2. Same period as the principal. And just like in the E's, the spouses will qualify for work authorization. I think we've mentioned it. The spouses will qualify for work authorization. The children will not.
Correct. Yes, that's with the E's and with the L, the spouses can have a work authorization, but children don't.
No, they don't. All right.
So now we get into the good ones, the ones that everybody wants to know about and we get frequently asked questions.
My intro to this is always, there was a Wall Street Journal article a couple years ago that talked about the purchasing your green card. And I thought that was a real interesting tagline that they had, like, you can go buy your green card. Well, people have asked me, is that really true? And it kind of really is.
Well, yeah, if it was only about money.
Right, if it only was about money, it is. So there is some truth to that tagline, but Angela, demystify our EB5.
Yeah, we'll talk about that one next.
Oh, yes.
Okay, so the first one, and we're going to touch bases on this one, the multinational manager executive.
Oh, yes, I did get ahead of us.
Yeah.
I'm sorry. So we're still on the L1A, but now we've gone from the L1A to what do we have for immigrant options, and what do we have for a multinational manager or executive looking to now not to be a non-immigrant, they want to immigrate. What are we looking at?
They don't want just the temporary L visa. We're getting closer to the 7 years. I'm going to run out of time. I'm going to have to go back to my home country. What do I do? Well, you can always file for the multinational manager or executive. You can even do it the first year. Well, not for a new company.
Right.
For a new enterprise, you can't do it within the first year because they want to see what's going on in that first year. But for the other cases, people who come here from companies that are already established in the United States, they can file for this green card petition, permanent resident petition, as soon as possible.
Right.
The interesting thing with the multinational manager executive petition is that the requirements are pretty similar to the L1A manager executive employee.
Right. And that's why it's sort of an easy segue, but it does have its own separate requirements. So the employee must have been working for the foreign company for at least one continuous year within the last 3 years. That's what sounds exactly the same. And must be entering to work as an executive or manager. So the L1B is not going to qualify for this leap over to an immigrant necessarily under the multinational manager or executive, as the title would lead you to believe. The U.S. company must have been doing at least business for the 1 year. So this is where we have that transition from the L1A to the multinational manager executive. Again, they look and read the same exact way, but there are those nuances that we want to take care of. If the company's not doing so well, does it look like he or she's doing a great job as a multinational manager executive?
Not only that, but they're going to be questioning whether this company is going to be able to support this executive to become a permanent resident.
Exactly.
So that is going to be an issue. Also, when you're looking at the qualifying relationship, here is where we can see the big difference or a key difference with the L1A. Because when you file for the permanent resident based on multinational manager or executive category, what they're going to be looking at is that the relationship, meaning the ownership of the share ownerships in the United States, are pretty much the same as the ones outside the United States. So, for example, if I owned my company in Colombia 50% and my sister owns the other 50%, but I come and open the company in the United States and I own 100% of the company in the United States, for L1A, that's perfectly fine.
Right, that's easy.
That's easy.
There's
You
an
can
affiliation.
come, there's an affiliation. But for this petition, it's different, right, Michelle?
Yes,
Because,
it is.
Yes, it is. Because what they're looking at is that you have the same ownership structure for both companies, the one outside the United States and the company in the United States. So if what makes the relationship is the ownership rather than the affiliation between the two companies. For example, the company in Colombia owns 100% the company in the United States, that's done.
That's easy.
No problem. But if they what makes them affiliated is that there's an individual that owns both companies or a group of people that owns that companies. They're going to be looking at the percentage of shares, how much each individual owns at each company, to make sure the relationship or the percentages are the same.
Right, so one of the first inquiries we do when we're looking at a multinational is, are you on an L1A based on an affiliation or on another one of those qualifying relationships?
Exactly. And that's one of the first things we look at.
Okay. And now we can go into my can you buy your green card,
Yeah.
right?
I love that one.
I love it too. So the EB-5 visas for investors, foreign investors seeking permanent residence in the United States. Angela, now can you demystify the EB-5 for us, please?
Well, it's funny because truly we get this question frequently about, okay, I had 500 or $1 million or whatever it takes. When do I get my green card?
Right.
Yeah.
Because it's that simple, right?
Yes, yeah.
No.
and
no, it isn't.
And I was once talking to this attorney, and he said something that stayed with me. And he says, well, for something that was created to be so simple, you create an enterprise, you create 10 jobs, and you have to prove within 2 years that you invested the money that you're supposed to invest, and you get your green card. The Department of Immigration, the regulations, the memorandums, the guidance, they had made this process so difficult that you might get a little bit frustrated waiting for your green card to come after you invested or try to invest the money, and then things are not happening for a couple of years, and they start asking for all kind of things. So what is the EB-5 visa investor? Those are for investors to come and permanently live in the United States. The United States only grant 10,000 visas of those a year. 10,000. That sounds like nothing, but believe me, for many, many, many years, we have not been able to reach that number.
Right, we struggled until recently.
Until a couple of years ago,
Yeah.
when we and this visa has been in effect since 1990. So just recently, a couple of years ago, we reached the 10,000 visas, to the point that there's now a waiting list for China.
Yep.
China is, yes, you get your approval.
So you hear all the news about how we're being bought by China. The idea is that we have so much investment from Chinese investors in this country to where they've pretty much, I think when we look at the numbers, they're a major part of those 10,000 numbers.
Yeah, but then you what happens? You get, yes, I got approved. I am in China waiting for my approval. You get the approval. Yes, your visa is approved, but I'm sorry, we run out of visas for you this year, so you sit there and wait until we have a visa available for you.
Right, so your petition's approved, but they're like,
You
oh,
can
even though
come.
we approved you and you meet all the requirements, there's not a visa available.
Yeah, so
We've
you
reached
need
the
to
10,000.
wait out there until we have a space for you to come. That's the problem we're seeing now.
That is the problem.
Now, what is it? Individuals who have invested or are actively in the process of investing, similar to the investor visa. Remember that whether you have already invested in the business or you are taking the steps necessary to start investing. You have invested the minimum amount of capital required, and you are investing into a new commercial enterprise. What does that mean? So what is a new commercial enterprise? As I mentioned, this concept, this category was created in 1990. So the creation of the company had to happen after November 29, 1990. It doesn't mean that if you try to buy an enterprise today that was created in 1989, well, that will not work, because they're looking at something created after November 29, 1990. But if the enterprise was created in 2000, then that would be good or considered new enterprise. You might also purchase a business and restructuring or reorganizing the business such that it might result in a new commercial enterprise. The best example, you buy a hotel,
Right.
and you restructure it, or you reorganize it in a way that it becomes a resort.
Yeah.
So there you go. There you have your new enterprise.
Who doesn't want to go to a resort?
Yes, who doesn't? So that is a new enterprise. Same concept, developed from the same idea, but became a new enterprise. Expanding. So you buy an existing business, but you have to expand it by at least 140% of the pre-investment number of jobs of the new worth. So you have to expand it and invest and create jobs that at least is 140% from the company that you initially purchased.
And
Now,
obviously, at this point, we're working closely with your CPA.
exactly. Well, very,
Yes.
very. When we do this type of business, there is a couple of people that we always tell people, you need to engage these people right from the beginning, even before we start working in the immigration visas. And that is a CPA or accountant and a business lawyer.
Right.
That helps to put together the business plan, the structure of the business, and that meets all the requirements. And then we can talk about immigration.
Right.
Now, retaining a business, a troubled business, they call it, is you purchase a business that is in trouble, that has lost, and that's what the regulation says. Business in trouble is one that has lost 20% of its net worth over the past 12 to 24 months. And you purchase it, and you're supposed to bring it up to
Resurrect it.
But also the thing is that you need to maintain the employees that
Right.
were in that business to be able to make it work for the EB-5.
Right.
So for EB-5, like the attorney said, it's supposed to be an easy concept, but when you start getting into these different things, you need to be careful to make sure that your enterprise is going to qualify for the EB-5. Okay. Now, what are the basic requirements besides of the new commercial enterprise? Well, the person the enterprise that you are creating, to be able to qualify for the green card or for the permanent resident petition, has to create 10 full-time employments within 2 years from the date the visa is approved.
Right.
So, for example, you filed a petition. It took the Department of Immigration, in some cases, like a couple of mine, 3 years to approve it. Then, after the 3 years, you come to the United States. They usually give people 6 months from the day of approval to the day they start working or they come into the United States, because it might take 6 months for them to enter the United States. And then the 2 years start counting, where they are going to make sure that you do create the 10 jobs. And what kind of jobs, what kind of people. So we're looking at permanent jobs, people that are U.S. citizens, permanent residents, or those that by law are considered to be here on a permanent basis and have authorization to work.
Right.
Those are specific classifications. And like in trouble business, as I mentioned before, that's the one that you're going to resurrect. You have to maintain the employees that were already working for that enterprise at the time you purchased it. And create the 10 jobs.
Oh my gosh.
Okay, so it's not just train 10 jobs. No, I didn't fire anyone, but here is the 10 jobs that were created.
That's why I like to use the word resurrect, because you have to bring it out of the ashes, or the phoenix.
And of course, as always, it has to benefit the U.S. economy. Same as the investor visa. Yes, you might have the money, and we want your money, but your business may not be so attractive that it will benefit the economy of the United States, so you may go back home with your money.
Right, and in some instances, we've had to call on economists to give us an expert report as to how this company will benefit the U.S. economy.
The economy of the United States, correct.
So it's not just the money that you have to have. You also have to look at what additional expenses you have just for the ability to apply for this.
So how much? When we say money, what are we talking about?
And this money, do I get to count against all the money I need to get from my business attorney, from my CPA, maybe an economist to do a report and help, and the immigration attorney?
No.
That's all counting in the investment, right?
Of course not.
Oh, gosh.
And here is what I always tell people when they're thinking about, I have the $500,000 or I have the $1 million and I want to invest. I always tell them, well, you may want to add somewhere between $50,000 and $100,000 more.
Right. I always go with $100,000
Yes,
more.
because you need to have that amount to invest plus the money to pay your attorneys, business attorney, immigration attorney, accountant, the business plan, people who are going to work on it, and all those ancillary expenses that will not, because you don't want the capital to fall short or below the $500,000 or the $1 million. So that's what we're talking about for the green card. Here we can tell you exactly how much you need to make this work. So the investment is either $1 million or $500,000. And just a little note here, there is proposed legislation as always, and has been talked about changing the minimum amounts.
Right, they want to increase it, don't they?
Increase it to the 500,000. They want to increase it to at least 800,000, and the 1 million to at least, I believe, is 1.5 million. But that spending. We just got recently now in September, they reauthorized the program because, believe it or not, the program has been in effect since 1990, but they still call it the pilot program.
I don't know how much more pilot it could be.
So, and they just keep it, is supposed to expire every year, and every year they reauthorize it for another year. And now this year, or for a couple of years, they have been talking about increasing the amount. So it's likely that we will see in the near future that we're not going to be talking about 500 but more, and we're not going to be talking about $1 million but more money. I don't know how good is that, but certainly it's going to be more money.
So whatever the amount is at the time, right?
Yes, but
what is it? What are we talking about with that capital?
Yes, but the difference between 500,000 and $1 million is where the money is going to be invested. Yes. Because if you open the business or the investment is going to be in an area called targeted employment area. What are these areas, or TEAs? Those are the ones that need employment development. Those are the areas that the government is looking for more employment to be created. So if you can show that the business is going to be in one of these TEA or targeted employment areas, then your investment will only be $500,000. And that, who determines what is a TEA? Well, that's the government, and they have different measurements. So and we usually get that data from them. No, so now, what are we talking about? The capital again. We talk about this in the EVs.
The idea that it be at risk. Again, we see be at risk. The capital must be subject to partial or total loss. Now, if there was any particular category that really, this is the part that's scrutinized, it is the EB5.
Yes.
Because a lot of investors, when they're looking at to invest that amount of money, a traditional business investor is going to look for a way to hedge and protect that investment. And here they want to take that whole safety net out from under you.
Yeah.
So, and it also, again, we go back to the same thing. It must be legitimate, lawful sources, not have been obtained directly or indirectly through criminal activity. Tracing is huge. A lot of going back to that 100,000 that you want to sort of recommend, imagine the amount of translation and a lot of documentation that we have to provide. And translations don't get, they're cheap.
And what I often tell people is you do not have to demonstrate where all your $10 million have come from. You just have to demonstrate where you got the 500,000 or the $1 million that you're going to invest. And that's a lot of money. And when you are demonstrating this, you're not only showing how you acquired that money back home or through your business, but also how that money came into the United States.
Exactly.
So you need to show the bank transactions or the transactions showing how the money came enter into the United States legally.
Legally, because there are quite a few nations out there that have limits on how much money can be transferred out of their country. So while you may have the money sitting in your country, can you legally take that money out
and bring it to the United States? In addition to that, we have in a lot of cases, or some cases, people are able to show, well, I had this $500,000 here in my bank in Brazil, and I brought it to the bank in the United States on this day, one transaction. But in reality, most of these visas, you can see different transactions, so you have to document each transaction, showing where the money comes from, how it got here, where the sources. So it can become a little bit overwhelming for an investor to gather all this documentation and have it translated.
Right.
That's an expense.
Yes, and having them wherever they have to go through various countries.
Absolutely. So the benefit to the United States.
Again, no guidance. It's a subjective determination. That's where we call sometimes on expert opinions from economists to sort of explain how this business enterprise is going to be a benefit to the U.S. economy. But the enterprise, in the conduct of his business, will benefit the U.S. economy. I wish we could give a little bit more direction to that. It's like, you know it when you... I wish we had
more direction to that.
It's kind of a you know it when you see it.
Yes, exactly. Now, there are two types of programs for the EB-5. And some of you may have already heard about the traditional program, which is you are the investor, you're going to invest the money, you are going to create the jobs, you are going to manage the enterprise, you're going to do everything. That's the traditional. And then you have the regional centers. And the regional center is a new concept that was created a few years ago. And the regional centers have become very popular, and there are over 1,000 regional centers across the United States. And what are these? These are entities that are created for the purpose of creating investment opportunities for those investors who want to obtain green cards in the United States.
Right.
These regional centers have to be approved by the Department of Immigration. So not everybody can say, oh, I'm a regional center. No, they have to go through the immigration process for the Department of Immigration to approve the regional center, and then they can create the investment program for foreign nationals, people to invest their money into their project. So what is the difference between the traditional and the regional center? They kind of have to meet the same requirements in terms of the capital. The capital has to be $1 million or $500,000. However, for regional centers, I would say that what we see more frequently done is that people only invest $500,000 because the reality is, why would you want to invest $1 million where you can get the same result if you only invest at $500,000?
Right, but again, this kind of goes to highlight that not every regional center is created equally, right?
Yeah, and that goes to the regional center, but I can, in my experience, in most regional centers, they do give options to people where if they only have the $500,000, then they'll have projects designed for only $500,000 investments.
Right.
But they will also have bigger investments, but most people goes with the least capital. Now, the benefit to the United States, both the traditional and the regional center, direct full-time employment, that is what direct is the company hires the employees. Right. That's the traditional. I have to show I hired 10 employees within 2 years that are U.S. citizens or permanent residents. For the regional center, however, because these are large projects, and usually what these regional centers do is they put a project together and they bring several investors to invest. So, for example, a regional center may say, we are building a
resort or call center
or housing or some sort of building. There's other regional centers that offer other types of investments, not necessarily real property. But they say, okay, we have this investment, we need 5 investors, $500,000 each, and this is what we're going to do. And so for that type of regional centers, they can also count the indirect jobs that they create during the 2 years. And the investor is passive, meaning you put the money in the investment and you just watch it.
And I think we've advised investors who maybe have the capital and have sort of this background, but don't want to directly be involved, they've been opting for the regional center because that's handled by the regional center.
Yes, and they can do anything else in addition just to get the green card, and it gives them a kind of peace of mind. However, here is where we always caution people to do due diligence.
Yes.
To when they're looking at regional centers, look at more than one and go ask questions. Visit the regional centers, visit the projects, understand what you're doing before you select a regional center.
Angela, how do you feel about attorneys that recommend regional centers, specific ones?
Well, I do work with a few of them. I always give people, the ones that I know, I give them their names. But
right, because
still,
we know that they're good.
Well, but I still give them a list of questions that they should be asking, and I also give them other options they can look at. It's up to the investor. It's like going to a doctor.
Right.
You need to feel good about your investment. You need to know that where you're going to put your money in is worth your time and your expenses. So due diligence, I can't stress that enough.
I know. That's critical. So how long do I get my green card then if I'm approved?
If
my
your
petition's approved.
Initially, you get it for 2 years. That's conditional. And meaning that during those 2 years, as we mentioned at the beginning, you have to prove that you invested the money and that you created the 10 jobs. If you can prove that, you give the documentation to the Department of Immigration, and then they just give you your green card permanently, meaning you get to stay here with your spouse and children forever.
So what are the steps?
We're going to go through this one quickly because this is not about that part. But
right.
To complete the process is you have to file that I-140 petition for the multinational or the I-526 petition for the EB-5. That's the one that if it is approved, then you can move to the second step, which is getting the actual green card. You can do it in the United States, filing the 485 petition, or at the consulate by filing the DS-230 petition.
The 260 now. Oops.
Exactly.
Yeah. And then after the 2 years, you file the removal of condition, right?
Yes.
All right. So I think we really hit it. As Angela mentioned, this is chock full of information. So I think we'll take maybe 1 or 2 questions, and then any other questions we'll be more than happy to handle via email.
Great. I know we had one question that came in during the chat, and it was, let's see here.
We have one question here, so.
Yeah, it was about the EB-5. Someone wanted to know, is that country specific? And if so, are there any country-wise quotas?
Yes. No, it's not. The question was, for the EB-5, is it country specific?
Q&A session has started.
The question is whether EB-5 is country specific or if there are any quotas. Again, EB-5, there's only 10,000 visas per year. But it's not country specific as opposed to the investor visa that you have to be a treaty country. For the EB-5, any person from anywhere in the United States that has the means may apply for this green card. There is a waiting list, and we just said, because we finally reached the number of visas that each country is allowed to have, but that's the immigration system. Each country is allocated only a percentage of visas per year, and like in the case of China, they reached that percentage a couple years ago, and therefore they now have a waiting list. But other countries, they are still current, meaning that as soon as the Department of Immigration approves that petition, 1, 2, 3 years, at this point I don't even know how long they're taking, then you will be able to get your green card.
Okay, great. And then we had another question as well. Would buying a franchise be eligible for an EB-5?
It could be. Again, we need to go back to what would be whether that franchise is considered to be a new commercial enterprise. If it was created after November 29, 1990, and meets the other requirements, it would probably qualify. Having a business in existence, you really need to do the homework to make sure that it would be able to be qualified as a new commercial enterprise.
Great. And then also, would a physician starting his own clinic be eligible?
The question is whether a physician starting his own clinic be eligible. And I imagine we're talking about EB-5s?
Yes.
Yes, of course. Remember, to do an EB-5, the basic requirements are a new commercial enterprise. So if I'm opening my own clinic and I can show that I'm going to invest the $500,000 within 2 years and create the 10 jobs, that should qualify for an EB-5.
I think that's pretty straightforward.
Yep.
Okay. And And that's all the questions we have right now.
Okay. If there's anybody else on the phone that want to ask the last question, we'll take it. Otherwise, we will be happy to send you the questions, the answers over the email. Anybody? No?
All right.
Great.
That just means we answered them all.
Great, awesome, thank you. So, as always, please, thank you first of all. Thank you for being with us. We will send you a copy of the presentation of the recordings. We will also send you a quick, short questionnaire, feedback survey, so you can tell us how we did today and what we should improve. We thank you very much for your attendance. Hope to see you again next time.
All right. Thank you so much.
Thank you.
Goodbye.